Research methodology is means of obtaining research results. In this video, we attempt to provide a brief overview of the main methodological framework for researching topics in law. As a PhD candidate in law, you will most certainly use normative or doctrinal legal method, especially if you're doing research on legal systems belonging to European continental or civil law traditions. This is the research focused on the so-called black letter law. It is best described as a method aimed at systematic scrutiny of rules, principles, and institutions in a given legal field.
Dogmatic method entails observing the positive law by analyzing different sources of law. This includes international sources such as conventions and treaties, supranational sources such as EU regulations and directives, and national sources such as various acts and regulations. Likewise, preparatory material, case law, and literature are important for the analysis. The aim of the dogmatic method is to collect, organize, and explain the legal regulation on a particular matter, as well as to find out what is the reasoning behind it. For instance, if the aim of your PhD thesis is to provide a novel systematization of existing knowledge on a particular legal matter, your research will probably rely on a dogmatic approach. The dogmatic method represents the basis and necessary prerequisite for any other type of analysis of law, no matter if it is comparative, economic, sociological, or empirical one.
Empirical method is traditionally more common to other social sciences than law, but for certain legal research, empirical method may be very important. For instance, if you wish to conduct research on whether female judges are more prone to establishing discrimination in the workplace, a mere observation of legal provisions might not get you far. Instead, your research question will require that you collect data, analyze it, and draw conclusions from it. Empirical research may be numerical, also referred to as quantitative, or non-numerical, known as qualitative. Quantitative research is based on numerical values and provides the answer to questions such as how much, how many, and how often something occurs. Qualitative research, on the other hand, is descriptive in nature, expressed linguistically, and focused on reasons why and in which circumstances something occurs. Quantitative empirical work can be done from your office on a computer, by accessing a database of court decisions or alike and using statistical tools for extracting and processing data. Qualitative empirical research, on the other hand, is primarily linguistic, based on narrative data and observations of a smaller sample, such as in a form of explanations or statements, which are then interpreted by the researcher.
Often, a scientific legal research necessitates a comparative approach to observe how a particular legal matter is regulated in different jurisdictions. Such approach is beneficial from the perspective of comparing the various elements of legal regulation across jurisdictions, identifying strengths and weaknesses, and drawing inspiration on how the existing legal framework may be improved. Considering the importance of comparative approach, as well as the frequency of its usage in legal research, we have dedicated an entire video of this series to its features.
Given that law does not exist in isolation, interdisciplinary approaches to studying law are gaining more and more significance. For instance, through socio-legal analysis, we may observe how legal norms affect social facts and social relationships, and vice versa, how social phenomena reflect legal rules. Furthermore, philosophy of law enables us to understand the relationship between law and values. Even if your research is practically oriented, you might wish to reach for the philosophy of law method to identify values such as sustainability or human dignity, against which you can measure the aptness, desirability, or other quality of legal rules or set of rules. What else comes to mind? Social psychology may be helpful, where social psychology principles help explain legal context, such as judicial decision-making or eyewitness testimony biases. Likewise, political theory may prove helpful in studying how legislators' choices are influenced by the nature and organization of the political life.
In search of an inventive angle, you may find yourself attracted to any of the other methodological approaches such as feminist analysis of law, experimental game theory, or various critical theories of law. In researching certain legal areas such as competition law or intellectual property law, economic analysis of law is frequently resorted to. For instance, one may be interested in researching how patent registrations which are later invalidated affect the follow-on innovations and super-competitive pricing, and also consequently economic benefits which patents may bring to society. Understanding economic policy could be an important step for a legal researcher interested in banking or fiscal regulation. Various other disciplines may become an essential ingredient to your innovative legal research, such as anthropology, linguistics, bioethics, neuroscience, or information and communication technology.
In this video, we have covered just a segment of the methodology of legal research. We hope we have sparked your scientific curiosity and convinced you to further explore and analyze different methodological approaches to identify the one which best suits your research.